Remind everyone, the little mics in front of you are going to be on for this part of the talk, so if you touch them, they'll make a lot of noise. And the second thing is, if you're going to ask a question, make sure the mic is sort of bent towards you, because then it will be heard better by everyone in the room, and also on the, oh, that's my cell phone. That's embarrassing. Sorry about that. So that's all. Well, that's all. Anyway, enjoy the discussion. I think we'll go to about 12, and then there'll be lunch. So enjoy.
Okay. I've been asked to moderate. We are gathered here in Oprah-esque intimacy. Let me begin by asking if any members of the panel would like to say something they didn't get a chance to say. Anything you want to get off your chest before we open it up to the floor? Anything you really wanted to say earlier didn't have an opportunity to say? All right, well, let's give you a chance to say something. Sir.
I detected a difference of opinion between Dan and Mark about the future of the clash, or not clash. Maybe we would just love to sit back and watch you two duke it out.
Why don't you go first? Are we all going to hell in a handbasket or what?
No, I don't think so. Absolutely not. These are very solvable problems. And the reason why they're solvable is because the economic advantage of solving them vastly overwhelms the cost of solving them. And so they will be solved. The question is how best to solve them, how to solve them quickly and efficiently. My view is that the SCO case was, it defined itself and was defined in the popular culture as some sort of cataclysmic Manichaean battle between good and evil. It's like all or nothing. It was perceived very much as all or nothing. And the SCO and the management at SCO was largely responsible for that, because they said, we own Linux. And if they deny it now, I have slides that they use that say, we own Linux. We own Linux, and the reason why we own it is because we own Unix, and Linux is an unauthorized derivative of Unix. So by sending out demand letters and asking for $700 per server approximately to 1,500 large companies in the United States, they created a sense that the whole process of open source development might be in jeopardy. The whole thing might just not work. There might be sort of a fatal flaw. And my view, and I think the view of most people who've looked at this, is that where we're going to end up is that litigation around intellectual property and open source will be routine. It is completely unrealistic to say there will be none. The goal should be that it is routine. It is just like how transportation companies pay settlements when their trucks go off the road or go through a red light. But no one says the transportation industry can't function because it's committing liabilities all over the place. It's absurd. The cost of traffic accidents is built into the cost of shipping goods. And the exact same thing will happen here. The cost of intellectual property compliance will be built into the enterprise cost of using Linux and open source.
Now, I wouldn't want to mess with a guy who says Manichaean, but you want to respond?
And I won't try and say it. I think Daniel's right from and if you simply look at the world that we've got today, Red Hat has had 2 IP suits in its now 11-year history, both of which settled on terms that actually gave us economic advantage. Microsoft, at any one point in time, has got somewhere between 35 and 40 active patent suits. If Red Hat had $35 billion in the bank, I don't for a minute think that we wouldn't be just as much a target for those persons bringing those suits than Microsoft is. We're just not as attractive a target right now. It comes up in other aspects of open source, in the whole area of when they talk about vulnerabilities to viruses and stuff like that. You know, we know that Microsoft gets attacked a whole lot more than we do right now. So you're not dealing with apples and apples, it's apples and oranges right now. I will venture a prediction right now that much of this will start to unfold, especially over the next 3 to 6 months. This is not the classic David and Goliath between Microsoft and Red Hat. This is a clash of titans. This is Microsoft and IBM. They each have vested interest in proving the other wrong. And so Red Hat's not standing on one side of the field all by itself saying, where's my help? We've got a lot of companies that have lined up on our side of the field as well, who believe, as we do, the system is not working properly. There will be economic reasons for it to resolve itself. For someone from Microsoft to assert that, take the Sun Kodak settlement, $500 million, Red Hat could never withstand that. Yeah, but Red Hat doesn't have the number of servers deployed that Sun does. It doesn't have the extensive Java deployments that Sun has. The size of the settlement was directly correlated to the size of the deployment. We wouldn't have a $500 million judgment or settlement because we simply don't have that much deployed right now. I look forward to the day when we do, and that I could face that sort of claim, only from the standpoint that we will have been successful at that point. But I do believe that economics will ultimately come into play here. What we will find is Microsoft probably has some valid patents, but not as many as they claim they do. There will be economic reasons for parties to work out licensing arrangements. I happen to be one of those folks in the open source community that believes that licenses in open source patent licenses in open source are not necessarily incompatible. It will, much like our business model at Red Hat, require some finesse, but it can be done.
Mark, you had a slide up there that interested me. I think it was you, and you identified some developments, unpatented developments in software from the 70s that, had they been patented, would just now be going off patents. Do any of you see recently granted patents that we might look back on in the same way 20 years from now? Are there particular patents that people in the software world are worried about that have blocking potential, that are likely to stand up?
Well, I would say, and I think Dan Ravisher, who did this study for Dan's company, would say identify the first and foremost of those to be the Microsoft File Allocation Table patent, or so-called FAT patent. And interestingly enough, Dan, in his under one of his other hats as the head of the Public Patent Foundation, is seeking a re-examination and has been granted, has gotten the Patent and Trademark Office to agree to re-examine that patent. So there are potentials out there. Will they survive a re-examination? Will they survive litigation? That's the key question.
What about re-examination? That's a difference between the United States and most of the rest of the world. We are much more rear-end loaded. Does the new re-examination procedure help at all?
I don't think it's been extensively used, especially the inter partes re-examination procedure, because the consequence of losing is so difficult on the party who brings the re-examination if it's not the patentee.
The res judicata effects?
Yes.
Yeah.
As far as re-examinations, I think they're routinely brought up by the patentee themselves. For example, if they are aware of prior art that they want to make sure is considered by the patent office before they go into litigation, it gives them a chance to draft the claims around it and still end up with something. So I think it's been reasonably successful for ex parte re-examination, but for inter partes, I just don't think it's used that much, because I don't think litigators want to go down that road.
You and your EU colleagues, I assume, want to learn from our mistakes. As you work on the software directive, what's your take on this discussion here?
Well, I found it...
What lessons are in there for others?
Extremely interesting. I was very interested on your positive take, optimistic take on what you think is going to happen. And it's also interesting from our side of the pond, where one of the biggest supporters of the directive as proposed has been IBM in the Business Software Alliance, which consists largely of US firms. So I think, they want some certainty. One point that will be interesting, if we do get a directive, it will be possible to challenge a patent in a national court under the national scheme and then go to the Court of Justice in Luxembourg, in which case we will get a ruling which is law for the whole of Europe. And that could have an influence on you because it will be a very visible statement of what some of this stuff means.
Any follow-up on this topic? Questions or comments? We can switch. Yes.
Let's see if you can hear me. I have a question about something that Dan said, that figure of approximately 50% of the patents that are adjudicated are invalidated, found invalid. I rephrased that right?
Yes.
Okay. Is that all subject matter, or were you talking about software patents?
Well, there's a whole academic literature on patent litigation, and there's a number of very good papers, particularly by this group called the National Bureau of Economic Affairs out of Stanford, and they've done a number of empirical studies. I can give you sites afterwards. We have a bibliography. My recollection is that the studies that have been done that are rigorous have been either general, that is, they just selected patents based on their numbers without any attempt to put them in categories, or in the area of biotech and pharma, which is an area where a lot of research has been done. The challenge of defining what is or isn't a software patent, it kind of begs the question, and therefore it makes it difficult to define that as a sector for which you do research. It's a little bit of a circular problem. So there has not been as rigorous empirical research in that area. My subjective guess is that patents in that area will be found often to be invalid. The patents in that area that were issued in the first 5 to 10 years after the idea of software patents became established are likely to contain a lot of essentially errors by the patent office or missed prior art, but that the process is tightening up, and that recent software patents are likely to be upheld at about the same rate as everything else.
One of the sources is if you go to the University of Houston Law School, they maintain a database. You can access a lot of the information. The 46 to 50% number is across the board, but they do break it out by fields. Interestingly enough, because of the lag time that's involved, there aren't a lot of reported cases involving software at this point. The percentage is higher for software, but the sampling is much smaller.
I'm curious, do you happen to know if more software patents get litigated or adjudicated compared to the other subjects?
I think somebody said that they thought they were being litigated at a higher rate. I don't think they are ending up in final adjudication, though, that most of them are being settled at some point.
Do you have any follow-up on that on the basis of your experience?
Well, having never had a patent invalidated that I was arguing about.
I know who I'm
I think 100% of the ones that I've been involved with have in fact
You have your business card?
been valid. So my only empirical anecdotal evidence is they're all valid.
Some of your partners must lose once in a while.
But I think that probably what you will see, and if I'd make a prediction, is I think the Federal Circuit has been going away from invalidating patents and toward narrowing the scope of the claims so that they won't be infringed. So ultimately there may be no liability, and if the percentage of liability, the 50% sounds a little bit high to me, but if it's liability versus no liability, then it sounds reasonable, and I think the way you get to that will probably change from invalidity in the past to non-infringement in the future.
So what the Federal Circuit hath given on the patentability side, it beginneth to taketh away on the enforcement side.
Yeah, although there's some speculation that the 112 enablement written description requirements may come back up as a possible defense in light of the narrowing claim scope interpretations. So it'll be back and forth.
Did you ever meet anybody who lost a case?
Yes, I did.
Well, this follows up on Timothy's mentioning of the reexamination in U.S. I think we would probably all agree that very soon, within a matter of one more session of Congress, we're going to see post-grant oppositions in the United States, and maybe you could comment on if you feel that that might clean up the act a little bit further, and maybe there's experience that Europe that we could hear of whether software opposition practice has made this a more respectable field in Europe.
Why don't we start with the European side, and then we can prognosticate about the U.S.
Yeah, well, there is an opposition procedure which you can bring in the European Patent Office, and as one of our colleagues said, I can't remember who today, that there are signs that the European Patent Organisation's examiners are tightening their act up. In fact, because I'm here, I missed a meeting in Brussels, which the Patent Office finally held in order to put their case to the Parliament. Not that the members will listen necessarily, but yeah, no, I think there's certainly a move to get this under control, which this directive is part of, and it's brought it out in the open. And the way in which claims are drafted is a very important part of this. What some of the provisions, if you look at the documents now, talk about the way in which claims should be framed, and I think this is most important.
Well, there's some economic issues that make it very difficult to engage in these kind of preemptive challenges. And the biggest problem is just that 95% of patents are never asserted or litigated. And so you may be spending all of these resources in validating a patent that is never brought against you or anyone else. There's also all kinds of free rider problems. If you're a large corporation and you have a large patent portfolio of your own, and the holder of the patent is also a large corporation with a large patent portfolio, and you're engaged in related activities where your products may be overlapping in terms of infringement, you have completely different incentives. One patent is just not that important than if you're a small company and this patent might shut you down. But the small company is unlikely to have the resources. So it's a very tricky problem to solve. And everything in patent law, one thing we know about patent law is every time we change one tiny little thing, it has a lot of totally unanticipated effects. So you don't want to jump in there with excessive optimism about something. The one thing is going to fix the whole system.
Do you agree that Congress is likely to expand the opportunity for reexamination, opposition?
Post-grant opposition.
Yeah.
There were two very good studies done, one by the Federal Trade Commission and one by the National Academy of Sciences, recommending various incremental reforms in the patent system. Both discuss in particular the issue of software and open source software, and I believe Marcus, you're quoted in there a couple of times, some excellent quote. Bob Young is in there, and Red Hat is in there a whole bunch of times. These are very minor incremental changes, and I think we will see some further narrowed subset of them getting passed. But in the meantime, we have to deal with these problems right now. A legislative fix is not going to be the way these problems get resolved for businesses in practical terms.
I think if you looked at that list that I put up there of proposed reforms, those that will probably be subject to more contention are adjustments to the willfulness standard and or injunctive relief, because while they have one meaning to those of us in the software industry to adjust those carte blanche to where they apply to everybody, they have entirely different meanings and have different economic effects in other industries such as the pharmaceutical industry. So I think when you get into those, you'll see greater differences of opinion being expressed.
Sir.
This is directed to Mark. Are you against patenting software in general?
Our corporate policy is that the whole concept of patenting software was a mistake. And when I say that, it's in light of not looking at patents alone, but looking at, unlike any other area of or field of art that I've been able to identify, software is the only one that gets 3 bites at the apple. You get trade secret protection, you get copyright protection, and you get patent protection. And to me, it's what is so damn unusual about this field that it deserves all that protection?
Well, I would argue that you don't get all 3 necessarily at the same time. But besides that, I mean, just assuming that software is a technical innovation, why would you want to exclude just one area of technology out of this whole global universe of technologies, ranging from pharmaceuticals to this, when I think the big issue in all this is the fact that it's a relatively new development, especially patenting, and there's a glitch. The glitch was a lot of patents may have gotten through the patent office without, sufficient review. But I guess I'd just like for you to expand this thought on why you just put software out of this universe.
Why excluding it from the universe? Number of reasons, and I'll try and tick them off for you. First of all, and I apologize for falling back to the pharmaceutical industry. It simply happens to be the other industry that I have tracked the longest during my career. Unlike the pharmaceutical industry, where the cost of innovation as compared to the cost of obtaining a patent is some orders of magnitude greater. For argument's sake, let's say the cost of obtaining and maintaining a patent is $25,000 to $30,000. The average pharmaceutical is going to cost hundreds of millions of dollars and typically take anywhere from 10 to 12 years to bring to market. That is not the relationship you have with software. It is inverted. In other words, the cost of obtaining the patent is an order of magnitude typically greater than the cost of the invention. This is the thin slicing of the cheese. If you look at what has been expended and the time to market that you've got in the software industry compared to an industry like pharmaceuticals, it is just vastly different. Time to market is shorter, cost of development per feature or function is less. The long-term value of that is far less. Moore's law pretty well still holds up within the technology industry. So companies in the software industry, you don't need a patent as an incentive to innovate. You innovate or you die. You innovate or you no longer have customers. That's why you innovate. Patents are simply, if you've done a bunch of it and have established a huge market presence, they become a protection device for you, a way to hang on to your position as opposed to advancing it. So that's probably the single largest issue. But beyond that, you do have these other elements of copyright and trade secrets. It's interesting, turning to copyright for just a second. If you go back and read the Cantu report back from 1978, you will see nothing in that report that implies that we should not have a full filing of source code to protect software. But in fact, that's not the way it got implemented. And even today, if I file 50,000 lines of code or 50 million lines of code, it's still 25 pages off the front end of the software and 25 pages off the back end. And oh, by the way, if I claim trade secrets, I get to redact all the trade secrets. And if you look at those filings, they're replete with redacted text out of the thing to where, how do you even know what they've got protected? So in fact, I seek copyright protection for a book, and I get it for a book, and I hand John that book. He gets to read the full text of the book. He doesn't see big redacted sections of it where I'm protecting all the ideas. I'm wanting to share my ideas. That's why I published the book. That's why I got the copyright. We have effectively extended copyright law on software to protecting ideas, not just the expression of those ideas. So I look at copyright, I look at patent, and then first and fundamentally, software was protected and continues to be protected to a large degree by trade secret, by binary-only licenses. And that's fine. Don't get me wrong. Do I think patents are wrong for all fields? No, I don't. Do I think proprietary software is fundamentally wrong? No, I don't, because if you didn't have proprietary software in some sectors, you'd never have development because there is not a big enough market there for it. But I think all those things add up to saying we just may not have gotten this right in this instance, and we need to go back and look at it.
Let me follow up on your question, and let me see if I can turn around your factual argument, which I think is correct, about the drug industry versus the software industry. But it seems to me the factual points you argue could also be the basis for concluding that, well, software patents are really not worth worrying about. Because if the things you suggested are true, then might we also conclude that most software patents are going to turn out to be practically worthless pretty quickly, that it's going to be easy to invent around them, and that there's going to be just a sea of prior art, orders of magnitude greater than you'd have in most fields, which will lead most of them to be invalidated?
Well, I think the prior art issue is, in fact, a big one, and it's why when you're seeing the whispering campaign about patents reading on the Linux kernel, why you're not seeing those patents be disclosed, because A, the parties who hold them don't want the patents to be invalidated, they don't want them challenged, and B, they are relatively certain that the open source community within a reasonable period of time can work around most of those patents, and all the evidence to date would support that from what I've been able to observe in my position.
I look at the software case not in like communications. I mean, there's thousands and thousands of telecommunication patents, and everyone just deals with it. You know, there's a lot of patents out there that people don't have to spend years and years and millions of dollars to develop. You know, they have a new way to modulate something, and they write it up, and they get a patent on it. But so I guess it just I think you're messing with something very dangerous when all of a sudden you just pick out a technological field and say, well, we shouldn't have patents in this field. And what about these small players that need to come in, and let's say they do come up with a new idea? How are they going to compete with Microsoft, you, or anyone else developing software in this area if someone can just come by and take that software and they don't have any type of protection to help get them an angle into the market?
If I can take your last question first, and I'm going to take it by deflecting it for just a second. One of our members of the audience here is Mary Masakia, who is former general counsel at SAS, now special counsel to the president at SAS. And I'm interested, Mary, where does SAS stand on software patents? I mean, how critical have they been to y'all?
SAS has the same corporate position that Red Hat does. We, as a corporate matter, do not believe that software should have ever been patented. We recognize that part of that water is under the bridge. We have very strong and vocal views against business method patents, and I was going to ask any member of the panel to address on business methods if they think, because of what we perceive as the exceptionally low quality of those patents, how easily they think it actually is to work around business method patents because of the way they are actually formulated. The other thing I would say is we disagree strongly with the comment that you made that trade secret and copyright really aren't used. Professor Conley was instrumental in the SAS S&H litigation in the early 80s, which was probably a seminal copyright case at its time, that I would say to John and anyone else publicly probably saved our company as they helped us win the copyright infringement case in that time period. So we rely most firmly on copyright first, trade secret as well, because we are a proprietary product, and like Red Hat, we have only started recently, like in the last several years, patenting software as a defensive mechanism only, not because we actually believe that it is viable in the marketplace or that it's a good use of economic resources.
Can I ask you two to define what it is you're opposed to? Software patents, what kind of patents? I mean, a diamond versus deer claim where it's an industrial process, but the novel, non-obvious element is the software implementation. What is it exactly that you think is especially pernicious here? What kinds of claims concern you?
Well, I think you hit on it earlier, John, when you were doing your presentation, and you talked about the paradigm shift with State Street.
Yeah.
And what happened with State Street wasn't just business method patents coming into play. It was a huge erosion of the non-obviousness standard that has now pervaded into other areas, including software. And part of what we're looking for as part of this reform is if the patent office isn't going to, of its own initiative, reassert that standard to narrow the scope of what is patentable, then we're going to need to do it
So
legislatively.
you want what I'd characterize as a European position where the non-obvious contribution has to lie in a technical area?
I in fact think that if we can come up with the right definition for technical contribution, that will in fact be part of the play here. We will end up with software patents. They will be drastically different than what we're seeing today, and they will not go to methods, necessarily methods or processes, as much as they will to actual technology features.
How do you think this is working out?
I've been racking my brains about this since 2002 and talking to some of the best specialists in the field. And if you've got a definition of technical contribution that solves this problem, you know, I'll buy you dinner in the best restaurant in Brussels. The thing is that there is a problem. I agree with the guy at the back there, that certain forms of software implementations deserve patentability when they are a real invention. You know, you get, you know, the software that drives, it's built in one of these tailor-made chips in your mobile phone, your engine management system in the car. I think those are probably genuine inventions, and the software forms part of it. You know, it's like a series of cogwheels, if you like, in the middle, which aren't per se patentable, but together with the thing that you have in your hand are patentable as an invention. It's when it spreads out from there. Processes are the beginning, the thin end of the wedge. But as you say, you know, an uncle of mine made a lot of money for inventing a process for calculating the shrinkage of pre-stressed concrete back in the 1950s, you know, which was a very useful, it was an invention.
God bless
but
him
it was
for it,
basically,
yeah.
it was basically a load of maths, you know. It was a load of math that he did in his head and then made it into a process. But, you know, it's a question of the dividing line, and that's what's so difficult to strike. If we could get a good definition, you know, that would possibly do the trick.
Yeah, it was interesting hearing a description of the telecom industry, and I think it raises a valid point, but there are clear distinctions here. There's no single dominant player in the telecom industry, and thus there is a strong incentive to cross-license. And the economics of the situation are somewhat different in that it is largely acquired as a hardware play. And if you look at the software industry right now, and I hate to cede ground to my colleagues at Sun on any point, but yeah, open source is not fundamentally, the economics of open source are not fundamentally built around the software. It's built around the fact that it has allowed the hardware manufacturers to commoditize as well. So that now Morgan Stanley, instead of having Sun Solaris boxes to where you have proprietary software on high-end proprietary hardware and paying a premium dollar for that, you have Red Hat Enterprise Linux sitting on Intel white boxes. I mean, I don't care who makes them. They just buy the components, stick them in there, get the cheapest box you can. And they're finding that the performance is equivalent, if not better. And there's a strong drive to commoditization. Major industry players, especially like Microsoft, are trying to protect turf by not allowing themselves to be commoditized. And I think the share economics are that they will be, unless there is a force that prevents it from happening.
That seems to me to be putting the patent system at the whim of a current economic situation. And I think that the argument that you made that software is cheap and easy to develop and is the exact reason why you need patent protection. Patents provide a barrier to entry into the market, and and it's in fact the exact reason why pharmaceutical companies want patents, not because of the long time it takes them to develop their product, but because once they introduce the product, it's very easy to knock it off. And the same holds true for software. It's very easy to knock it off once you've introduced the product.
That's why we have copyright.
Well, that's great if you actually make a disk copy of it, but if I see what your software's doing and write my own program, then you're out of luck. So I think the software is directly analogous to the pharmaceutical industry in the sense that if you want people to take that risk of jumping into the marketplace where if once they take the step to release their product, they may be eaten up by the 1,000 other people or in, I guess your view, worse, Microsoft, who then says, oh, that's a good idea, and then implements their own with their giant sea of developers. Where is their incentive to come up and take the risk of doing something and trying to provide something new?
Well, I think the economics start to break down when you try and make that comparison because if you're looking at the capitalization of the two industries, it's far different from pharmaceuticals. You have a far larger capital investment on the front end, taking extraordinary risk that is even going to play out to something than you do within the software industry, and consequently, there would be no incentive. I absolutely believe there would be no incentive to invest in the pharmaceutical industry if you didn't have some form of protection that's going to allow you to recover and to generate sufficient funds that you can continue to carry out that level of R&D. But there is no corollary within the software industry. It doesn't hold. Most of the software has been created without patents. I mean, you look at the major players that are out there right now, like Oracle, you have SAS, Sun Microsystems has got patents, but they've contributed a tremendous amount of code as open source at this point in time. Not because they needed the incentive of patents to go do it.
Tim, do you see copyright as not being up to the job here?
Yes.
Why?
Frankly, because it doesn't protect the idea. And what the people invent is not doing something, it's the idea of doing it and how to accomplish it. Especially with something where the way you accomplish it is with a generic programming language, right? That just is an implementation.
You want to take copyright away? These are inventions, these are not literary works?
I don't have a problem with copyright. I don't see any reason why they can't coexist. I think that, independent of whether or not you can keep it as a trade secret, that seems reasonable. But I don't see any reason why they can't coexist in the sense that you shouldn't be able to just directly copy somebody or take their, and that's a different issue than whether or not you have taken their idea.
I'm a copyright lawyer, but I'm not going to get into that. I'm just sort of curious because I keep, know enough about patents to be highly dangerous and call a patent lawyer. But I'm curious as to your paradigm of saying that because it's cheap to invent, then it doesn't deserve patent protection. I mean, there's a whole bunch of physical things. I mean, like the staggered windshield wiper blade didn't. Some guy in his garage did, so they're not deserving of protection. I'm sort of missing that link that how much you invest in it should be tied to whether you get a patent or not.
Yeah, and I don't know, in not being a patent attorney as well, so I'm off into dangerous grounds myself, but and I don't know if I can adequately describe this, but when I look at the windshield wiper example, it's a functional instrument. I can see it in its entirety. I didn't have to go and figure out what the blade was, and I didn't have to go out and figure out what each component of the movement of that wiper. I didn't have to figure out what the rheostatic device that controlled the intermittency was going to be. Those were all disclosed as a part of the same patent. But here I'm having to look at 14 patents on the positioning and movement of a cursor. I mean, it's the number and the degree of examination that's required is just staggering at times.
I was trying to think what the role was that you were espousing. Yeah, I mean that latter argument I think says you could get better patent examiners, better prior art, and not have that kind of mess, then the patent office is responsible. I'm just trying to think of, I'm not sure whether I favor or don't favor software patents. I don't know enough, but I'm just trying to see what's your test. And I guess it isn't necessarily amount invested.
Dave Harlow is going to give us the answer.
Well, without trying to comment on it one way or the other, I think what Mark may be proposing, if you make it more abstractly, what the rule would be, is that what we're talking about is the definition of subject matter. And software, because of its intangible nature, is much more difficult to get your arms around. And so it's always, not always, but ever since software's been around anyway, a subject of a lot of debate as to whether or not it's subject matter. I think what Mark is saying in an abstract sense is you make a policy decision as to this particular difficult area of subject matter, and you draw a line where you want that policy line to be, because a significant part of the innovation in that industry is not tied to the need for patents. You don't need patents to drive innovation there. The overall constitutional policy, after all, is the exchange of the monopoly in order to get the innovation. If we're not getting sufficient innovation there, then it's appropriate in a policy sense to legislate or otherwise say, we cut subject matter off here.
And not going specifically to the patent system itself, we've seen this phenomenon in terms of probably perhaps the greatest invention that will have come about during my lifetime, and that's the World Wide Web. I mean, Tim Berners-Lee could have said right off the bat, I'm going to go get a patent on this stuff, and the rest of you guys are going to have to pay me for the rest of your life, and we wouldn't have the web as we know it today. It has evolved and continued to extend itself at an unbelievable pace because it has done so without the burden of patents. And despite the rather significant battle that took place within the W3C over this issue a few years ago, they finally came down with a royalty-free patent policy. So the patents can exist, but if you want us to apply them as a standard, you got to provide them to everybody royalty-free. So go ahead and innovate, choose to protect, but if you want to see widespread adoption, that isn't the way you're going to go about doing it. It's going to happen through widespread sharing, and consequently we've seen the web, we've seen the Apache web server, which is by far has the largest market share and is totally open source, unencumbered. Things like SendMail, which is again the most prominently used email client, Firefox now on the browser side. These things are not coming about because people perceive the need to protect the ideas. It's because they're in fact willing to extend them. And so the model here is not a traditional capitalist model. It is an academic model. It's putting out good ideas, subjecting them to peer review, obtaining peer recognition, which is important. If you think it's important to professors, I can tell you it's important to software engineers that work in the open source community, because it tells them where their standing is among their peers. The economic reward tends to come later, but it does come.
Mary, now that your cover's been blown, let me exercise the professorial prerogative to call on members of the class at random. You talked about SAS's philosophical policy opposition to software patents. Has SAS's experience been that patents held by others have been a significant impediment to its own innovation?
Oh gosh, that's a tough one. We certainly, and again, while we have a philosophical opposition to software patents, our major concern in this day and age, and particularly since State Street, because of the discussions that you all have articulated, has been in the business method area. And if you understand what our product is, which is business intelligence software applications, it is a much greater concern than if you were an IBM and you'd had software embedded in your machine as an operating system. That isn't where we play. Certainly, anybody in this industry gets the letters. The pirates or the terrorists or whatever you want to call them, they do exist. They're real. They're out there. I don't believe it enhances innovation, nor do I believe that it has good economic value. And so it has not changed what we have done. It hasn't impacted where we have gone, but it certainly is a drag on resources as you have to deal with this type of activity, I guess, for lack of a better word. I'm not going to say how many letters a year we get and that, and I'm not going to say whether or not we have paid fees to various companies to deal with this problem, but it is real. And I think you have to turn around, and this is where I really agree with what Dave is saying on a philosophical basis. When you go back to the Constitution, you know, we say IPR, intellectual property rights. Well, it's not a right. It is something that is granted by a legal vehicle. It doesn't, you know, you don't have a, it's there and it's articulated. And the quid pro quo on that right granted in our Constitution was that you have to do a disclosure. You have to show. And the reason was so that somebody could take that disclosure and then innovate beyond it. That was a social quid pro quo, and it was the way that we thought from a public policy basis you would extend innovation and have a better economy. When you look at the types of patents that we have been most concerned about, and I'll give you an example. I call it the Judy Jetson patent. So for those of us that are old enough to remember Hanna-Barbera's Jetson cartoon, you would see Judy and her mom sit in front of a TV screen, and they'd be trying on different clothes, and you'd swap a blouse across and a skirt and shoes and whatnot, and eventually they'd say, oh, I'll buy this. Well, I would have said that they should have gotten the patent that was granted in one case, where it was a, you know, an implementation method using a computer to select clothing, sizes, colors, and fits. And I'm going, well, shoot, I saw that in the 60s as a kid on a cartoon show. This was a granted business method patent. Now, what did they disclose that would allow me to invent beyond it, create economic value? And where was the quid pro quo here that society really was looking for when they did that? And I would say it doesn't exist for the most part in half of the business methods that were given, like the lawyer that filed a business method patent and got it for his kid because he thought it would be cute, which was how to go on a swing. And if we remember when we were children, we'd sit sideways on the swing and we'd go back and forth and say it was a horse, as opposed to going forward and backward. Well, this gentleman patented it. You know, I applaud the fact that his child now has a patent in his name because he observed it. But, you know, truly, this is the type of thing that has been going on for the past 4 or 5 years. And if you are going to engage in something where society 200 years ago gave you a constitutional right to help the rest of us, then let's not go down this road. So we like Europe, and we would like to see you make it stronger, and I'll be happy to sit down with you and Mark afterwards, and we can talk about ways to talk about a better definition. We hope the U.S. goes in your direction and not in the direction we've been going.
You know, you're, but what do you really think? That's always a problem with
Somebody
Mary.
blew my cover.
You never know what's on her mind. I wonder, though, listening to you and Mark, to what extent we're arguing almost about procedure rather than substance. Because, you know, we can all come up with examples of silly patents. I often hand out to my students the Three Stooges weight reduction machine that has a patent on it. But, and we laugh about those patents, but they never cause any problems. In the U.S., we're back-end loaded, hugely. Patents get relatively low scrutiny compared to Japan or Europe at the front end, but we rely on economics. You said 95% of patents never see the light of day. And we rely on the judiciary to make sure that the Judy Jetson patent doesn't jump up and bite anybody. Other systems do this early on. Are we really concerned about the substance of the law, or do we get where you want to go by keeping the law the same but moving the screening back to the front end?
Well, John, let me ask you this then. Do you consider State Street substantive or procedural? And do you think that as a business I should rely on the federal circuit courts to move from that substantive decision and eventually go to where we're going to limit infringement by virtue of narrowing the claims, which maybe you could argue is procedural, but I'm still, as a business, dependent upon what I had not expected to happen with State Street, and now I'm expecting an evolution over time where they might correct or narrow what they've done. Now, do you consider State Street substantive or procedural?
I consider State Street a lot less substantive than I think most people do, because I don't see the substance of the patents being allowed changing a great deal after State Street. Because I think Tim and his pals had gotten most of those patents allowed pre-State Street. So I don't know that it changes all that much. I do see, as you're suggesting, the reliance on back-end screening as a huge transaction cost for business. On the other hand, I get very nervous about killing geese that may be laying golden eggs, and to mix metaphors, upsetting apple carts and all that kind of stuff, and asking the patent office to perform a kind of function that it's historically never performed. And this could be the ultimate unfunded mandate. You know, we're going to tell you to do this, but we're not going to fund it for you. So,
Well, one more thing, and then
but we should get the
turn it-
European comment on this.
And this will actually go to the European, to that issue, because the USPTO has for many years been working, I believe, with the EPO and the JPO to try to get global harmonization.
Yeah, the
And to
trilateral.
the extent that they have been pushing to have Japan and Europe move in our direction, that in fact is a significant policy direction, and that would have Europe and Japan coming to where our patent office is, as opposed to the reverse. So I would be very curious as to where Europe is with.
When the trilateral group does its tests, though, on business methods and software, the way I read them, the results don't come out all that different. But we're going to give you the last word, actually.
No. Okay, well, I must say this has been really informative for me, and I've really enjoyed it, and I've learnt a lot. It's interesting, actually, that when you're talking about backloading, the French system is much more similar to the American. They don't examine the claims, and if you look at the common position, there is a provision at the end in the review where they say we must examine what implications this has, you know, for
Those
good
French,
or for ill.
certainly.
Yeah, so you know, we're conscious of that. We've got the same problems. Certainly, I think there was a pressure to move towards the American system, but I can see this being resisted now. You know, just the sheer resistance. We've had people on the streets. You know, you don't get people on the streets about intellectual property. You know, I get Universal Studios in my office. I get the music industry taking me out to lunch, but I don't get people demonstrating on the street. And you know, that really hit home. You know, they had pictures of leading protagonists saying, you know, let's get this person. You know, make sure he or she is not going to be voted in again. You know, this is the people talking, and it's dangerous. I think the whole policy issues behind intellectual property are absolutely fascinating, and I think this is a really interesting test case, which is, you know, kind of bring us forward. I hope we will succeed where you haven't yet, but I wouldn't bet on it.
That's a good note to wind up on. So thank you for your questions, and thanks to the members of the panel.